Hi, I'm BJ with the Law Office of BJ McKinney. I want to share with you some information about a new program for deferred action for childhood arrivals. I will be doing several videos in regards to this program, but I want to share with you today some general information about the program, the eligibility requirements, and the criteria. The policy design. The policy design of this program allowed for ICE and for Customs and Border Patrol to really focus on priority cases and at the same time meet a real need for children who have been in this country most of their lives, and it gives them an opportunity to work without the fear of being deported. This program was designed for individuals who came to the United States as children. If they meet general guidelines, they may be eligible for a 2-year period to defer them from any type of action on behalf of immigration, and they'd be eligible for a work permit. What is deferred action? Deferred action for childhood arrivals is a form of prosecutorial discretion. It allows deferral of prosecutorial action against those who accrue unlawful presence due to their continued unlawful status in this country. In other words, it defers prosecuting people that are here illegally and giving them an opportunity to work. What is deferred action? It is still a non-legal status. It does not confer legal status. There is no pathway to citizenship, but there are some major benefits. So how can it help you? What are those benefits? Well, in deferred action status, you don't have to worry about being deported. You have the opportunity to attain a work permit. I listened to a young lady who arrived in the United States when she was 2 years old, and she explained she grew up watching Barney on TV. She went through high school and didn't realize until she was in high school that she was different, as she explained. I didn't know I was different, that I was illegal. She received a 4.0, and then she looked for a college and had a very difficult time. She found a college that would accept her. She went 4 years and received a 4-year degree, and now she cannot work. This opportunity provides her with a work permit. It is a wonderful opportunity. It also will give the potential for travel. After you have applied for the deferred action and you've been approved, you can apply for advanced parole that will give you the ability to travel and hopefully see loved ones that you have not seen for many years. I want to talk a little bit about the criteria. There's an age criteria. You must be under the age of 31 on June 15th, 2012. So if you had a birthday today and you were 31, but on June 15th you were 30, you're eligible for this program. You also must have come to the United States by your 16th birthday. You must have been here before your 16th birthday. You must be 15 years of age or younger to be eligible for this program. I want to talk about physical presence. You have to have continuously resided in the United States from June 15th, 2007 up to the present. You must have been physically present in the United States on June 15th, 2012. And when you file your application for deferred action, you must be present. Also, any time spent outside of the United States during the last 5 years must have been for a brief stay or for a very casual stay. Now, there is an entry criteria for arrivals in the United States. You must have entered without inspection, without going through customs, before June 15th, 2012. You can't show up now and be eligible for this program. Or you are out of status as of June 15th, meaning if you had a visa and that visa had expired. Now, there's an education requirement. There is an education requirement or a service requirement. You must currently be enrolled in school. You must have graduated from a high school or received a GED. If you're not in school today and you did not receive a GED or a diploma, you can enroll in school today before you apply for deferred action, and you'll meet that criteria. Or if you served in the Coast Guard or Armed Forces and were honorably discharged, you're eligible as well. Now, there's a background check. There is a background check. You cannot be convicted of a felony or a significant misdemeanor or 3 or more misdemeanors. and you cannot pose a threat to our national security or otherwise threaten our public safety. Why do you need a lawyer? There is some risk involved. You still are in an unlawful status. If you have any criminal conviction, you may be automatically deportable. These are situations when you definitely need a lawyer to review your specific case. Every case will be different. Since this process is discretionary, you have to keep in mind that the final decision on whether you're approved is by the USCIS, the United States Citizen in Immigration Services. And you need someone to help you put that application together, bring all of the necessary documents and information so that you will have a complete application to be submitted. There is no appeal. There is no appeal except in a few circumstances, so it's important to have a lawyer. If your application is submitted incorrectly, there is a strong possibility that the USCIS will not review a subsequent corrected application. So it's important. So what can you do? Well, first of all, you can consult an immigration lawyer, stay out of trouble, gather all your evidence, as much evidence as you can, to prove that you meet the criteria mentioned that I've mentioned earlier, and get it together and have it ready for submission. I am B.J. McKinney. I have practiced law for 30 years, many of those years in Texas and some of those years in California. I can help you no matter where you live. Give me a call at area code 619-677-5658. This is a wonderful opportunity for childhood arrivals who meet this criteria. Our next video will focus on evidence, and I will go through in great detail the type of documentation that will be needed. Thank you.